Alex here with part 94 of the My Docket series on child custody and visitation. After my previous videos, I'd like to take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one large example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We move on now to my motion to compel. So, the past couple of videos, we were dealing with my ex's attorney's efforts to quash a subpoena. In other words, to suppress or hide information concerning my ex's mental health records. And now we move on to my motion to compel, which is to force them to turn over the identities and names of any other psychiatric, psychological, mental health providers that my ex may have, which would then lead to more discoverable information. So pretty much same exact principle. I'm trying to get more information in front of the court, and my ex and her attorney are trying to keep as much information as possible from the court. Hiding information is the name of their game, and bringing information to the court is the name of mine. Discovery, the purpose of discovery is to get information to the court. Typically, anything that's relevant is admissible. There are exceptions to that which involve privilege, and then there are, of course, exceptions to the exceptions, and we've talked about those a lot in the previous two videos. My mindset here is probably the same as in the past two videos. I am once again dismayed that my ex's attorney and my ex are trying to hide information that is clearly relevant, but I think this is due to both the win-at-all-cost mentality, see the video, and also due to the things that I bring up in the video, self-representation bias, or I guess more appropriately, exploiting the judge's self-representation bias. It's not like, I mean, attorneys are always going to be against self-represented people, just like they're against their opponents. But when it comes to the court, you would expect judges to be a little bit more understanding. But when it comes to, at least in my experience, the family courts, there are some judges who have a bias against self-represented parties. In fact, not even just the family courts. You know what? It's probably just that. Honestly, it's probably the most common bias, even more than gender bias and any other kind of bias. Number one top bias is most likely self-representation bias. Going straight into it, let's take a look at what I have filed. Here we have my motion to compel my ex's attorney or my ex to turn over the identities of psychological and psychiatric providers. Just one tidbit of information here. I expected this to be my ex's attorney's reply to my opposition, but this is not that video. So I know I mentioned that in my previous video. That will eventually come up. I don't imagine my ex's attorney skipping the reply. She most likely did file a reply to opposition. We'll take a look at that when it comes out. Motion to compel the respondent to disclose the identities of psychological and psychiatric providers. The introductory paragraph is pretty standard. It's me identifying myself to the court as the petitioner, indicating that I have no attorney, and I am stating here that I'm filing a motion based on the following points and authorities. Here we have the points and authorities. Factual background. Typically, the first paragraph is the summary paragraph. March 3rd, we were in the midst of separation. My ex phoned me, and then we go into the same summary that we went into in my last video. We're going to avoid bringing this up for the same reasons as that last video, to avoid this video getting yellow flagged. Looks like the same mention on the police report, so we'll move past that. It looks like this is also reiterated. All of this is reiterated. All of it is, including the last paragraph. So we'll go straight into the argument here. It looks like it pretty much is the same principles. I'm trying to get information in front of the court. My ex is trying to prevent that from occurring. Argument. My ex's, looks like our son's teachers To our son's teacher, my ex's conduct was so beyond the realm of understanding. Okay, so this is also being reiterated. And here we have, okay, so here we have the rules of civil procedure. I can obtain discovery regarding any matter that's not privileged. Notice it doesn't say any matter that's not confidential. It says any matter that's not privileged. That's the distinction there, which is relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other party. This statute here says in determining custody of a minor child, sole consideration is the best interest, which is the same. This right here indicates this is a case that states any party is allowed to discover any information that is reasonably calculated to lead to the discovery of admissible evidence. And this is the sort of principle of you can discover relevant information, and then you can also discover something that will lead to relevant information, which is what I'm trying to argue here. I'm trying to argue that the names or identities of mental health providers will lead to actually calling them as witnesses in the case. And it actually states it right there. The disclosure of the psychiatric and psychological providers is necessary so that I can subpoena them and documents in their possession. We lead into Rule of Civil Procedure 16.21, which requires the court to compel the production of documents. Conclusion. It's in our son's best interests that we have these psychological and psychiatric providers disclosed. We're going into the signature, the declaration, which is me stating under penalty of perjury that everything factual alleged in this document is true, under oath. Here we have the certification of consultation with opposing counsel. I don't even know why I put that in there. This is required. This is required in the Rules of Civil Procedure. Yeah. And then, of course, the pending motion to quash supports that we have consulted. Here we have the Rule of Civil Procedure number 5, which is indicating I serve this motion upon my ex's attorney. And here we have the motion opposition notice, which is indicating that I did not have to pay a filing fee. Wow, that was a quick document. Police report, which we already went over. Same as the last document. Most of this overlapped the last document, which meant there was a lot to not go over. Of course, as with my previous video, everything is down in the description below. You can always click on the link, download it, take a look at it yourself. If there's something in there that you want to ask me a question on, post it down in the comments and I'll answer your question. But yeah, everything that I went through with all those previous citations I covered in the previous video. And then, of course, when it comes to this police report, I covered that in part 2 or 3, can't remember for sure now, of the My Docket series. Subpoena. So as I mentioned, I knew these were going to eventually end up in the docket, and here they are. We can now go through the subpoenas. This is a subpoena commanding the discipline coordinator to appear before the family division, and here's the address, the date, the time, the location of the courtroom, etc. And the purpose of this witness is to testify on our son's disciplinary incidents. This is a special certificate of service, Rule 45, subsection B1, which requires that this, even though my ex is not the target of the subpoena, I'm still required under that Rule of Civil Procedure to show her the subpoena so that she knows what I'm trying to find out, so that she can intervene and quash it if she thinks it's necessary. Next subpoena, this is to Coral Turner, front desk secretary. Same exact thing as the previous subpoena, except here I am trying to get her to testify with regards to our son's absences right here. And here we have a certificate of service. By the way, guys, this could have been handled better. One of the things that I could have done is try to see if the court would allow me to issue requests for admissions, which would then allow me to get my ex to admit or deny these absences. And if she denies them, then I can bring this witness to court and really embarrass her, because she'll say, yeah, my ex didn't take her son to school. But if she admits them, which is all, it's possible because she knows that she can't really get out of that lie, she might admit them. By admitting them, she would then obviate the need for me to bring this witness from her job into the courtroom. I explain the importance of understanding this in the video Witnesses and also in the video Discovery. Definitely take a look at those 2 videos, because there are some things that you can do to make it so that you don't really need to bring certain witnesses to court. And part of that is forcing your opponent to formally admit that certain things have occurred. Here we have another subpoena. This one is a duces tecum to Willow Springs, and they are being commanded to produce, let's see here, the physical addresses and telephone numbers on file for a person named Shirley Luce. That must have been the first mental health expert. Next, we have another subpoena duces tecum. This is to a teacher, and this is going to be on our child's weekly homework submissions, behavior, and conduct of parents. Here we have another subpoena duces tecum to West Hills Mental Institute. This would be to turn over the documentation. Here we have Coral Academy of Science. This is on, what is this to turn over? The address on file for kindergarten teacher. This is the kindergarten teacher that put together the affidavit, that really important affidavit. And so I'm trying to find her address so I can have her searched so she can be compelled to appear as a witness in the case. And here we have Rule of Civil Procedure number 24, subsection 2, request for submission. Let's see. What is this? Oh, so this is just submitting to the court? Oh, okay, so this is out of order. This is on the next document, but you know what? I'm not going to flip these around. This is fine for now. Most of my viewers have seen like 30 of these different requests for submission, so they know what these are. If you want to learn a little bit more about them, please watch the video Request for Submission. But this is basically submitting to the court this document here. And this is my request for the court to refer all of the discovery matters to the Discovery Commissioner under Rule 24, subsection 2. This will allow the Discovery Commissioner to take these off of this judge's plate. And that's number one. Number two is I've had a lot of good experiences with this Discovery Commissioner. He is a great guy. He applied the law very strictly, very formally, and it shocked me because I had such a different experience with the family judge. The way that this guy approached the issues before him was completely different. It was academic, it was scholarly. He went through the motions that you're required to go through as a judge, even though he wasn't a judge. That's the irony. He was a commissioner, which is a type of master in Nevada, which is not a judge, yet he was acting, in my opinion, more like a judge than my true and actual family court judge. Rule 5, Certificate of Service, indicating that this motion, what? This isn't a motion, this is just me requesting. Well, anyway, it doesn't matter. Indicating that this request for the Discovery Commissioner to preside over our case, indicating that I wanted this, or indicating that this was served to my ex's attorney. Going into the aftermath, I filed 7 documents, no 8. Looks like everything. I filed all 9 documents, and I did incur some costs here. The motion was a free filing, and the request and the application were free filings, but the subpoenas weren't. There are 6 subpoenas that have to include a check, at least to the witnesses, not necessarily to anyone else. And I think there's 2 witnesses that are commanded to appear. It basically amounts to $26 plus 26 cents per mile. I'm not going to bother looking into how many miles away they were to get you the exact cent, but I will say that both of those should have come around to around $52 in costs. The other ones that are requesting documentation, I can recall having to pay for some documentation on one of them, but I don't remember how much it was. So, I mean, it wasn't going into the triple digits. It was probably something around $30 to $50. But since I don't know, I'm just going to omit it for now. And then there was 1 or 2 witnesses that I was trying to find the addresses of. So if I was to get those addresses, I would then have to subpoena them and pay costs. But at this point in time, that hasn't happened. So there are just 2 subpoenas that I have to pay the costs on. So we're going to leave my costs at $52. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, she probably would have reviewed the subpoenas. I doubt she would have spent a lot of time on each one. I think it's fair to say 30 minutes for all 6 subpoenas, and not even just to review them, but also to consult with my ex on them, as in, who are these people? Why might he want to talk to them? What might they say in court? Stuff like that. And we know that one of those subpoenas she tried to quash, so I think 30 minutes for all 6 subpoenas is reasonable. Request for submission and my application to refer to the Discovery Commissioner, negligible. Let's just leave those at 0. And then we have the motion to compel. I really feel like that one, it could be like 5 or 10 minutes, but just to err on the side of caution, we can say 15 minutes. There may have been some discussion there over the phone with my ex on what it was that I was trying to compel. She may have needed to ask her, hey, do you even have any of these other psychologists or mental health experts that he doesn't know about? You know, just to find out maybe her opposition should be that there just aren't any. But anyway, I think 15 minutes is reasonable. So that's going to bring us to a total of 45 minutes at the rate of $250 an hour. That's going to come to 125 plus 62.50. I think off the top of my head, that's like 187.50. And you'll see the true number on the panels to the side of my head. Anyway, that being said, if you have any questions, feel free to post something down in the comments below. And I will see you guys next time.